Would you like to learn a brand new and innovative way to invest your extra money that has a low barrier to entry and low competition? What if I told you that it is a guaranteed method to get up to 18 to 20% return on your investment? Tax lien and deed purchasing is the only way to get into the real estate market through the back door. No credit and no loans needed. This method isn't commonly taught, and therefore the competition is very low, for now. Put together a 14-hour info-packed course which will teach you everything you'll need to know to get started. Learn at your own pace, step-by-step guided video and aids to start you on the TLC deed investment process. The course offers many learning tools for new investors, helping ensure you safely invest in tax liens and deeds. Contact us today and join the buyback team.
Welcome, welcome, welcome. Oh yeah, I got all black on tonight, so I'm just kind of melting in with the ambiance. How you doing, guys? Welcome to Primetime Home Buyers, the buyback team with Lashley. Let me see, can I change my background and get a little bit suitable? It looked like my shoulders is knocked off my back, Let's see. Is this a little bit? Maybe it's the position. Okay, I think I'm better. How about this? Let's try this tonight. How are you doing, guys? Blessings, blessings. Welcome to Primetime Home Buyers, the buyback team. You're here with your host, Lashley. Okay, your buyback team leader and tax lien expert. So today we're not specifically talking about tax liens. We're going to continue on into another real estate topic that many of tax lien investors, tax deed investors, homeowners have to deal with. But this particular section, because we kind of been going down a yellow brick road. Tonight, we're going to focus on renters' rights. Okay. So last week we went into, evictions, a little bit about squatters, what to expect about the eviction process. We went into it in detail. So today we have another formal live. I'm going to put a PowerPoint on there. So I want you guys to get your pen and paper. It's going to be a little bit long. Hopefully it don't be too long, because I had to make sure that I put everything that I felt was important to the renter. And as I say, as a tax lien investor, tax deed investor, and especially if you're taking my program, I want you to have a full perspective, not just your goals, what you're doing, how you want things to be. You want to be able to interact with people properly, understand their goals, what situation they're in, what they can do, how they can move. So you as a landlord, and renting to a renter, you will benefit from listening to this too, because it's a lot of things that renters can do to prolong their stay, as well as get some things thrown out. All right, so let's get it started. I hope you guys are having a great night. And I started a little early today because I want to have a little talk through at the end. And if anyone wants to come in and ask me questions or just put questions in the comment, we can do that. I'm opening the floor up to you guys. Okay, so I'm going to put the PowerPoint fully on the screen so you can be focused. Okay, so this is Primetime Home Buyers Fighting an Eviction for Renters. Okay, fighting an eviction for a renter. If you are a renter, this is for you. All right. Talk to your landlord. That's the most important thing that we can stress. Communication is everything. In these days, there's a lot of things that's going on, and it's not just you, the renter, that's in hardship. It's the landlord as well. And I know sometimes that can cause friction between you two, so we will talk about that when you're not able to communicate what to do. But in most instances, you want this to be your first go-to. And as I mentioned, if you can't talk by mouth, make sure that you talk by text, by email, or something that can be documented between you guys. Okay. So when you realize, these are times when you want to get in contact with your landlord. When you realize that your rental agreement is about to expire, because as a landlord, we're looking at it like, hey, we're about to get this apartment rented. They're not saying anything, but usually a good landlord will send you a notice and say, hey, do you want to extend your lease, or what is your plans prior to that? So if you don't see that, it is your responsibility to move forward. When you realize that you aren't able to pay your rent, not the day your rent is due, but everybody knows when they're getting into hard situations, and sometimes you can't set up a payment plan. Okay. When you have an additional occupancy, if any new damage has occurred to the property, that was supposed to be in the other bullet, I do apologize. But one, when you have a new occupancy. If it usually landlords put in their rental agreements how many people can stay in the home, especially if they're strict in the area. You can't have 7, 8 people, those type of things. But regardless, if it's hardship going on and there's a certain time frame that you expect the people to stay, you may can talk to your landlord to see what you can negotiate. Okay. So if any damage occurred to the property, that's very important. If you damage the property, if the property has a natural disaster, water leak, broken stove, things like that, you want to address that as soon as possible. If you become involved in any criminal action, I know many people ain't going to do that, but it's very important for you to do that. And the reason why is because um, in most states, if you have criminal offense, you can't be the first leaseholder in many situations, depending on the situation. Okay, and that's usually part of the lease agreement. So you want to be transparent. Some of them will work with you like, okay, what do you don't do nothing here. Okay. Anyway, so rental issues, having trouble paying your rent, that's when you want to definitely give them a heads up. Now, talk to your landlord and see, can you set up a temporary payment plan? As we said, discuss future financial options related to your income. You can say, hey, I'm about to land this job. I know people don't want to hear all that, but you can say, hey, this is what's going on in the near future. I'll be able to pay this and maybe be able to show just a little bit of proof. Okay. Ease things over just a little bit before you have to go to court, before court even happens. Adjust the rent due date a few days or weeks. This can happen, especially if you've been a renter for the landlord for with the landlord for a long time. They will work with you, especially if they knew you're honorable, they're honorable. This can happen. A lot of institution does this too. Even loan companies, I can change my actual payment date, not every month, but I think once in the quarter, once a year, or something like that. Okay. Be sure be sure to make sure all agreements is in writing and is signed by both parties. This is also known as an amendment to your rental agreement. Well, it'll be considered an amendment, okay? So you want to have everything documented. Don't just have somebody say what they're going to do, because they can get in front of that judge and change the whole thing up on you, and you don't want to be in that situation. So document, 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 okay? So, rental issues, additional occupancies, just a little bit more into it. I'm kind of going into details. In some cases, family members may have to cohabitate. In this instant, it is important to talk to your landlord and see what you can negotiate. If this is in violation of your rental tenant occupancy agreement, I do apologize for the typo. But because if this is in violation, if it's not in there, you may not want to, you just, till they say something. I'm not saying be like that, but if the boat ain't rocking, don't rock it. But if it is in the rental agreement, you want to highlight that, okay? Sorry for the typos. I thought I fixed everything. Y'all know last week we having some drama in her house. I be trying to fight through the current. No, it's not drama. My house is my teenagers trying to distract me. That's my drama. Anyway, rental issues continue. Rental issues, damage to the property. In any cases, all damage should be reported to the landlord if it is the tenant's fault or natural in-house disasters. The landlord is to give the tenant ample time of notification of when they intend to be at the property to fix the damage. So you have to know that you have the right, that the landlord can't just show up at your property and say, I'm about to fix this now. You can be on your way to work, taking your kids to the doctor, those type of things. This is why this is set in stone across many states, that they have to give you time, a time frame when they're going to be there. Okay. No matter what the situation is, discuss options with your landlord and you can work out a deal. Now, if it's little things like plumbing issues and you have to buy a little part like a new lever, something like that that goes in the toilet, those things can be deducted out of your rent. Or if you have to hire a handyman, that can be deducted out of your rent, but you want to negotiate before you do the action, because sometimes when you do it, they'll just be like, I didn't tell you to do that. But in any instance, if you get in front of the judge is going to make them reimburse you because that's fixture to their property and they're responsible. Okay. There's people like that, but you still have rights. Just keep your receipts. So continue to fight an eviction. Okay. What to do when you receive a notice? As I say, communication is everything, guys. Never ignore the notice. Always respond. Even if you like, you know, you're not in the right. Just respond. Give yourself some time, because if you don't respond, it's going to cut the process short and you're going to get a default judgment against you, most likely. So respond, because you want to do these administrative actions accordingly. Try to be try to be uh, try to be compatible as possible. If you don't agree, respond accordingly. So you want to, kind of be like friendly as possible when you agree. Okay, just try. If the notice is if the notice is unclear, you can respond by asking for more information and or proof if equitable. Now, you're going to be able to ask for proof during the litigation, but you can't contest and say, hey, I didn't do that because of this, because of that, and you can state your claim at that time. Okay. When responding, highlight what you have done to comply or be in compliance with your lease or and situation. So if you're not in this, out of complying with your lease, and that's not the issue, whatever the situation is, if they like, hey, you got this going on, you could be like, no. If they say this is a situation, you'll be like, hey, I got this proof. Okay. Keep all receipts of rental payments, payments made to fix the property, and receipts of lost goods. Yes. In some cases, when the homeowner is responsible for securing the property, not to the like total extent, but it has to have locks, adequate light. Um, Sometimes in certain areas, certain other requirements are required. So you want to kind of check your specific jurisdiction, especially if you're in the city, because if they don't do that, they'll fine them. Okay. So you can use that in your complaint and be like, hey, well, they never have adequate light. It's always broken. I put tickets in. That's why the people were able to break into my house and take their time and come through the back door, because nobody could see it. And this is why they should be responsible for some of my lost goods, of all of them. Okay. So you can use that as your defense. What to do when you receive a notice continue. Document all interactions between you and your landlord, highlighting emails, telephone calls, and texts. Yes, keep every single thing. I'm not telling you to record, especially if it's getting ugly, but if you're in a one state recorder, state like Georgia, meaning that you can record, if you a one party recorder state, I do apologize, you will be able to record someone in the state of Georgia and it'll be legally submissible in court. In all states, that's not applicable, so you have to know when you can use that tactic. Okay. Never stop communicating with your landlord unless it's a hostile situation. At this point, you will keep all documentation of proof and submit it to the courts. Respond to all letters in a timely manner. Yes, I'm not telling you just to respond, but it's a timely manner. You cannot respond when you just want to. You have to. Date of response, due dates should be highlighted on the notice. Look for the due dates. Look for phone numbers. Some states require you to respond in writing, but if you cannot do so in a timely manner, make sure that you can contact the court and document who you spoke to. Okay. And also sometimes you can correspond by fax and email too. Okay. Attending the hearing. When you're ready to attend the hearing, I already talked about what to expect, in a general process, just, for both sides. But as a renter, you want to kind of hone in on your position. Before you face the judge and submit all your proof, in many cases, the court will allow you to speak to a mediator. So this mediator will look at everything that you have to submit to the judge, your proof, hear your story, and they'll do the same to the landlord. Okay. The mediator is a mutual party who works for the courts or sometimes volunteers. Okay. Sometimes they just volunteer hours to get through their law school, things like that. Within the mediation, you and the landlord could present both sides to the mediator. As an expert, the mediator will suggest a resolution, especially because they have seen so many cases come before them. So they're kind of going to know, like, okay, I'll give you an example when I finish this PowerPoint. If no resolution can be made, then the matter will be forward to the judge. So, for instance, well, they had to take me to court in the state of Georgia because I mentioned to y'all one of my property, well, rental, when I was renting, had mold. So basically, when we got into mediation before we went to the judge, not only did the mediator remember the company, not the person, but the company, and it being remarkably familiar, the same type of issues. He just made a suggestion that they may want to settle before they get into court. If not, they can go and fight their case, which is, because he told me, ma'am, could you step out for a minute? I was like, okay. After I showed all my stuff, I had it in order, A, B, C, D, everything. And that's basically what he told them when I stepped out the room. Okay. And they end up settling. So a mediator could stop you from being in front of the judge and having to present, because that could be a little bit intimidating and time consuming, because certain judges are really funny and they want you to present and talk a particular way. Okay. Sometimes I'm not being funny. They're like, no, 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 start again. Okay. So that's a mutual party. So that's how that works. Okay. Let's move forward. Renter's defense. Let's talk about a little bit of the renter's defense. A little bit what you can do. Okay, so renter's defense. Rent was not paid late with an explanation. Like, for instance, maybe the deposit didn't go through. I don't know. Your check was late. It came in on the next day, but you made the payment to withdraw a day before, and that was supposed to be the same day. So if you show the judge the proof, like, this is when I usually get paid on a Friday, and this particular time it came in on a Sunday, and I was late with the payment, and they just took me to court, just like trying to get me out of here. That can be a defense. You have proof that you comply with everything within the lease. Document. You have some people that's just hateful. You never received an eviction notice. It's very important. As I told you, you have to get that first notice, and i.e. that notice is not a court notice. You have to get at least a letter from the landlord saying, hey, you're back, this amount of rent, this is the charges, this is the time you have paid to pay. And if you don't pay, this is when we're afforded to the court according to the law. If they, so fancy to put it in total writing like that. Okay. So if you don't receive that, you can use that as your defense. Like, I never received that. All I received was a court notice from here. And most people don't know this. Once they receive a court notice from court, they're like, oh man, it's over. If you receive a court notice from court first and you don't get a written notice from your landlord outside of court, like weeks prior, that is an administrative issue. And you can use that as a defense. And this is why I tell the buyback team it's very important to put your people on notice. No notice time, know what's supposed to be in the notice. That's why I'm very strict on that, because it's two sides to the game. I used to be a renter, okay? So the eviction notice was not correctly worded. The person didn't understand what they was talking about. They didn't highlight the correct things that was wrong. That can be an issue. No highlighted time for resolution. They didn't. You got to have a consideration. You got to have a time where they can pay you. So that is part of a contract. Remember, we talked about contracts. When they send you that notice or that bill, that's like a contract. So you have a certain amount of time on a due date to pay that. So if you don't, then you basically forfeit it. Does that make sense? Victims of domestic violence or abuse. Yes, I know landlords be probably like, oh, I don't want none of this stuff going on. But usually victims of domestic violence or abuse would choose to move, especially if it's an event that happened. And with that goes, you can break your rental agreement, or if your landlord has another unit for you to move, they can opt to do that, in some situations, where I had a fire at my home and my landlord he called me. I'm just gonna tell you what he said. Called me. I was at work working like a worker, And I got off at 4 and I checked I have 3 voicemail. The first voicemail said, "Baby girl, the house is on fire." And then about another second voicemail was, "Baby girl, the house burnt down." And then the last one said, "Baby girl, call me when you get off. I'm sorry, I know you're working." I'm like, oh my God, I'm driving home to a burnt home. So with that goes to say that landlord was nice enough to put me in another unit. That's why you want to have good communication. Be good. Treat people good. You'll get treated good because you never know what's going to happen. Don't get into people property and start acting ugly, like just messing up their stuff because it could do you wrong too. Okay. So evictions based on discrimination. Now, I will say this is something very hard to prove, like many people say, because you have to have documented proof. You got recordings of the person saying something that falls under discrimination, behaviors, track behaviors, as well as statements from other people who had these particular issues can be taken in consideration. But just know that discrimination is a basis, but you have to have substantial proof. A little bit more renters defense. You see, renters, I got some good stuff for you. Now, landlord did not fulfill their obligation to provide a safe and livable dwelling. As I tell you, the lighting, secure locks, they have to have it. If you live in like a building and the outside door is always open, they can be responsible if something happened to you. Livable dwelling, the water has to be running. Some people have their water incorporated in their rent. And I have heard of people having the whole like housing complex water shut off and come to find out the homeowner skipped the country and they have like a $15,000 bill. And these people are basically having a lien on their rental property and they have to get out, you know? So that can happen. But in those instance, you can still go after the landlord if they're accessible, take them to civil court. Okay. You were not aware of the illegal activity. As I say, if y'all get caught up in some illegal activity, like for instance, I had a gentleman who told me he was like, I was coming from work, he just looked like a regular guy. Y'all know how that go. And he was going to the store and he ended up getting caught up in something on the way coming back. Like all the boys standing in front of his building, this guy ran down on. And as he was coming in with his drink and stuff, he looked like, he talked to them. Hey, bye, la, la. And the cops try to put something on him, not put something on him, but whatever happened. So he had to represent himself and get himself out of that situation, show he was a working man. He just got home. I know those charges was dropped, but then it could affect his rental situation. So in that situation, you will be able to show some, facts like, hey, I didn't have nothing to do with it. It was a misunderstanding. And maybe the landlord move forward to evict you, especially people who are in hard situations. People working 2 and 3 jobs barely could pay their rent and then you get evicted. And then sometimes in the clause of your eviction, they want to keep your security. And then some of these landlords find upon themselves to find issues, things that you like, no, oh my, I have to clean the whole floor or the carpet clean is 500, things like that. So please keep good communication, okay? And protect yourself. Landlord evicts you illegally by destroying and or discarding your property. We showed you a video last week where a landlord was acting. Did I? Oh, I saw that on TikTok. Just acting crazy. You can't go in there and just throw people's stuff out when you don't have a formal possession first. You gotta have the eviction. You get the possession, then you get, the sheriff. They'll move them out. That's the process. You communicated with the landlord prior to court, and they never respond. That can be, the judge may not throw it out, but he will probably consider it. But you want to bring it up because some judges probably just strict, like, no. So she replied to you and you didn't respond. You didn't try to get this together before you got here. And that may fall heavy on the landlord too. So show your proof. Landlord evicts you because you joined a support. Oh, look, landlord evicts you for complaining to local agencies. It happens. The politics is bad these days. It's always been bad. So if that happened and you can prove it, that's part of your defense. And I want y'all to know this is for information and educational purposes only. I'm not a lawyer. This is all, based on research and common sense. So I don't want you guys to be like, Lashley said do this. All of this information, a lawyer, you can verify with a lawyer. You take this information and ask them these questions, okay? Very important to be ready when you're dealing with a specialist, as I told you guys too. So, landlord evicts you because you joined a support group, organization, or tenant organization or union. Now, union, that's far fetched, but organizations where, they probably don't want you to, Crime Stoppers, and then the landlord is the, person doing the crime. You never know. Okay. So, if you can prove that, you can win your case. So before a judgment is granted, what can you do? Okay, before the judge say, all right, I made my decision. This is what you do while you're presenting your case. Like that's why you want to go after, or if they ask you, do you have anything else to say? And you kind of listen. Like if you present your case first and then the landlord presents their case and it's just good, and you like, damn, I'm about to get evicted. This is possibly what you could do. Okay, let's make it make sense. I'm just giving you another kind of one last ditch effort as well. So before the judgment is granted, what can you do? If you believe that all your defense may fall short, you may want to request a continuation or a stay. We're going to go into that, okay? A continuation can be granted when a person would like to receive legal advice from an attorney or gather more evidence that is already available, okay? So at that point, you done heard this argument. You're like, wait a minute, I need a lawyer because, wait, I'm confused, okay? And the judge will sense that you're a little confused. And they'll be like, okay, you can get a continuation. I need you to when you have a lawyer, they'll probably tell you, okay, we're gonna send you a notice and you let us know, did you get a lawyer by this time and things like that, but respond. Some states may allow you to continue the um, hearing date later. Sometimes you can ask for a continuation more than once. Yes, you can, depending on the situation, especially if you're sick, person's in a hospital, that's the person that owns the like, okay, for instance, if you have two people on the lease, let me give you an example, and one of the persons on the lease is not well and they're in the hospital, and y'all both should be there, and that person wants to be there, and you paid your rent, because I'm going to tell you what you got to do as far as paying your rent to the court will give you leeway and say, hey, well, we're going to delay this case until this person come out if it's a reasonable illness, things like that. Does it make sense? Okay, so please keep in mind that continuations are not granted in some states related to illegal activity and criminal offense. So if there's any criminal offense things going on, they probably like, no, I'm sorry. Especially if it's a known drug area and things like that, and the person is a felon, they looking like a felon. The judge ain't trying to hear that, and that's what I tell y'all. Go looking presentable, okay? Your aura means everything. What to do after a unsuccessful defense, okay? So after you miss that time, that to say, hey, wait a minute, wait a minute, don't, because the judge's going to ask you after you had that person, your landlord talk, do anyone have something to say? And if you miss that time and he say, okay, eviction, then this is what we should do. You may want to do. Filing an appeal. When you file an appeal, it essentially puts the eviction on hold. One more thing I want to mention before you walk out that quote, if you have anything to say and you forgot, this is just information educational purpose, is to say, hey, can I get a continuation? You're going to say, hey, I want to appeal. Okay, so it's going to be on the record. The judge's going to be ready, and they're going to make sure that they get your documents out in a timely manner as well. Okay. So that is when we're talking about appeal. There's a bridge between the first case and the second case that you want to keep in mind. Allowing the tenant to stay in the home until the proceeds is completed. So when they do the appeal process, you let them know, then the person that's like an El Stapo. Okay. The appeal takes place in the higher court, not the same court, and sometimes can be sent back down to the lower court for a new trial or for additional evidence to be added to the case. Okay. Yes. Please research the law. Please research the things that I have showed you. I gave you a lot of tools to be able to research this for your particular state. Okay. Some states and eviction cannot be overturned by the higher courts. Sometimes they just can't do it based on the law. Okay. only if only if a legal mistake was made within the hearing or at the time of judgment. Illegal thing happened or something that was not happening, administrative action. That's why we always tell you, we say going through all of this so you can know the administrative part of protecting yourself. Going into court is not just going, I'm do this, I'm gonna say this, I'm gonna sue you. It's administrative action, it's guidelines that they follow, so you want to know them so you can maneuver through easy. So example of a mistake or something that was wrong. Example, witness are not allowed to talk, or you were not able to defend yourself properly. And if you can prove that, sometimes you can prove that within the transcript. Okay. The transcript says it all. And that's why if you're going to go through, like, I want a court reporter, I want a court recorder. Okay. Like, or you can ask them, do I get a court recorder? Don't say I want one. Like, can I do this process comes with a court recorder? Can I request it? And the judge will be like, yes. Okay. They usually won't tell you that, but you can, because that'll give them a heads up that you're about to take it to the upper room, another level. So what to do if you're unsuccessful? Continue. File an appeal. So these are different types of appeal. Just know it's not free. Sometimes you got to pay like you weigh. So it'll break down all three processes. Depending on the state, you may have 3 appeal options, which is appeal by bond, appeal by cash deposit, appeal by statement of inability to pay. Okay. In some states, you may have no more than 3 to 5 business days to appeal. Please know your timeline. There are fees that are associated with filing an appeal. Be sure to notify the lower courts at the end of the judgment that you plan on appealing the decision. Okay? So you want to do that. Like, hey, I'm going to appeal. Appeal by bond. What is it? When a bond is entered into the court, it is a promise that you will pay the judgment if you lose the appeal. You will be able to sign the bond with the courts. In some situations, they require an asset to be attached to the bond. Oh, it's a bone. I do apologize. Look at that. I'm gonna have to fix my PowerPoint. Don't worry, guys. I'm gonna fix this PowerPoint, but we're gonna get through it. The asset is supposed to be attached to the bond. Okay, so just keep that in mind. Okay, and that's not always, but if it's a large amount of money you owe, they will ask for it. Also, if you file a rental bond in many states, you must pay 1 month period of rent to the court of registries within 5 days of filing the bond. So it's not free. You're going to have to proceed like you're still renting and go pay that next month rent. And that's great because the court's got the money, not the landlord. Okay. You also may have to pay for filing fees for the appeal within 20 days. And they're going to send you an appeal notice sometimes, or you can do it right there in court if they let you. Appeal by cash deposit. In this case, the judge will tell you to file an appeal by cash deposit. The judge will set the amount of the deposit. It is usually equivalent to 1 month's rent, but the judge do have the discretion. Okay, that's what I said. Be nice. Be nice. You also must file an answer to the court within 8 days of receiving the appeal notice. So they're going to send you appeal notice, and at the bottom it'll tell you file a response. But most likely when you do the application, it'll have your full response. But if it tells you to file a response, just file a response, a copy of what you already sent, if that's what you want to do. Okay. Some places are redundant like that. It is very important not to miss any deadlines. It is best to file your answer and pay the fees at the same time as soon as possible. So when you file, you want to pay. Even though you got 8 days, 5 days, you could file, but you want to make sure that you're going to be able to follow through. Okay. Appeal by statement of inability to pay. So this is like filing a waiver for payment. In many states, there are baseline guidelines that may allow a person to file under these terms. So guidelines includes financial situation, okay? Depending on your gross income and the state's requirement, you may be able to file. An inability to pay, which is highlighted by a fee waiver. This fee waiver is put in place of the amount that you would have to pay for the bond or cash deposit. So remember, it's just for the bond and cash deposit. The sworn statement of inability to pay is filed as an affidavit with the court. If the landlord disagrees with your fee waiver, then you may have to prove your financial status. So always have your pay stubs, have them ready. If you're getting assistance, get those letters ready. Call your caseworker, because you can show pay stubs, or like, I don't know where people get assistance, but if you get assistance, people, you want to have letters from your caseworker stating the program that you're in, and how much they pay and all of that on legal paper from them. Okay. So appeal by statement of inability to pay. If you are granted the free waiver, you will still be responsible to pay, but you won't pay right away. Okay. You will still submit your payment to the court registry as normal, with you will pay your landlord. Okay. But that will be actually the month that's coming up. Okay. You want to verify that with the state. But at that time, you'll have like basically 30 days, or whenever your next month is rent due, that's when you'll have to deposit your month into the courts. All questions asked by the court should be answered within 5 to 7 days, depending on the state requirements. Paying money to the registry does not forfeit your appeal or stop it. So even though you're doing your appeal, you got to put that money in the registry. Just do it in the lower courts. Your money is protected. I liked it because I said, hey, I ain't gonna spend it, because if I owe this money, you never know. But I have my rent, so I said, good, it's all there. They can't get it. I can't get it. Okay. So paying your money to the registry does not forfeit your appeal or stops it. If you do not pay the landlord or do not deposit into the court, the landlord could be granted permission to remove you out without another hearing. So they will sort of win the case, okay? But at this time, you may still be able to fight the grounds of eviction, but you will have to, or may be required to get out. I know it sounds like, what? I still have to get out. But if you want to fight it, you still have terms. A lot of people don't want to, especially if that happened. But if you like, okay, I'm going to stay with a friend. I really know that I can get my place back. This is really ridiculous. Let me just do it like this. Okay. So sometimes you could just, but you don't want to forfeit your attempts to do this. So you want to kind of like move accordingly. Okay. Challenging a court order, eviction continue. What you should know. Okay. Removal of a default judgment. All right, we getting to the end of this. Removal of a default judgment. Yes, renters, you can get a default judgment removed. Removing of a default judgment. In some cases, if you miss your eviction trial, you may be entered into default judgment. If you have a good reason, why you missed the trial and have a defense for the case, you can ask the judge to remove the default judgment. This is known as a motion to remove a default judgment. Okay, guys, come up with a good reason. I'm giving y'all more last ditch efforts. Okay, and as landlords, y'all need to notice, if the people notice, your stuff gonna be delayed. Okay, I just gotta tell the truth. Okay, so you also can challenge the court eviction order. All right, I'm giving y'all another hint, y'all, by postponing the eviction. Now, how do you do that, renters? If you do not win your eviction case, you may still have time to postpone the eviction. You can file a state of eviction. Have you ever heard of that, guys? This is usually granted if you have an elderly person over the age of 60, or if you have a disabled person within the apartment. So this is how you can get under those terms, okay? These days we have, I don't know, mentally disabled fall under that, but it could be, because if someone's schizophrenic, it's not safe for them to be out in the streets, especially if they have a history of, a lot going on. So you can bring that up. Okay. The courts may, in some cases, grant you up to 12 months stay. Yes. Okay. Sorry, landlords. I had to tell them. Up to 12 months stay, depending on the state. Okay. Challenging a court order eviction. What you should know. Postponing the eviction. Another reason for a state to be another reason for the state to allow you to be to the order to stay to be granted is if the tenant agrees with the eviction but needs a little bit more time to find another place to stay. Now, if the judge see it reasonable and they see like, okay, this is a decent person, they work, they do this, and they literally looking for places, you can have a rental app or something, and then have all of the places that you have visited there, things like that there, and just tell them like, hey, this is where I look for apartments, this is the app, and this is what I've been going through, so I just need a little bit more time. They've been out my price range, but I'm kind of looking into this area now. Something like that. Judge will grant you some more time. In this case, you must show the judge that you have made serious efforts to look for another apartment. Postponing the eviction. A judge may also grant a motion to stay if you have someone who is severely ill within the premises. Okay. That could be cancer, that could be lupus, things like that. A lot of things will fall under this. You need to just check with an attorney or you do your research. Okay. All right. So we got a last ditch effort. If all else fails, okay. Did you know they could do this, landlord? All else fails, a last ditch move. If you are ordered to still vacate the premises, depending on your state and county, you may move forward to try to request in order to try to stop. No, in order to try to stop the move. So it's an order to stop the move. That's what it's called. In this case, you will have 24 to 48 hours to go to the constable or the sheriff's office to request that. TRO. The same person that's about to evict you, if they give you 4 days, you need to get down there and say, I need this paper, because they have rules, regulations that they have to follow. And y'all didn't know this. Some people didn't know that. So a TRO, a temporary restraining order, that will postpone the postpone the consul's move out. Okay, so is the that's the constable or the sheriff. Okay, it'll postpone it. This temporary restraining order may be granted up to 10 days. You want to check your local renters guidelines. A lot of actual courts know that a lot of rental disputes are actually argued between the landlord and the actual tenant, and not all the time with the lawyer. So you would be able to find online how pro se how to represent yourself in court. Not court, they do have that too up here down south. They have that whole document up there on the courts, like up here in my county, but how to represent yourself in landlord tenant court. Okay. So now we're going to get to our closing statements. I'm just going to round this stuff up. I do apologize for my typos. I thought I got them all out. Them kids been getting on my nerves, y'all. I'm over here trying to get myself together for y'all. My daughter coming in with drama, my intuition going off and stuff. I'm like, what's going on? I'm calling her phone. I'm just telling y'all a little bit of my drama. Always got some daggone excuse. And y'all know I'm OCD, so I don't be liking mistakes on my stuff. So I'm going to fix that up and we're going to handle that. But anyway, that's my OCDness. I'm ridiculous. So remember what we talked about today. Some of the things that we talked about that you may not know is the form of appeals that you can do. Okay. So these appeals do require you to pay. Or if you can't pay, what can you file? A fee waiver. Maybe name something else in your county. But what that goes to say, you want to apply for the affidavits of inability to pay. Everybody will know what that is. And then you'll put the required information. And it says you must pay the rental period that is coming up. Most likely, that's going to be the guidelines. So you will hope to give you another 15 to 20 days to pay what's coming up. But you'll still have that back rent due that you are actually, fighting for, but it's not due at that time. Okay. That will be due if you lose the whole case. You see what I'm saying? In most cases too, if you have that back money, you can put it in the courts at that time. I told y'all, because if y'all keep the money in your hand, y'all like me, sometimes things come up and you just got to pay. You like, okay, dang it. So you go put that money up in the courts to handle your business. So other forms of appeal is appeal by bond, as we mentioned. So this is a promise to pay if you don't beat your appeal process. And in some cases, they want an asset. They're like, hey, put your car up. how much your car worth? $30,000. You know, like this apartment ain't worth no 30. They're gonna be like, well, we're gonna put a lien on it. And that's like another, that's a lien. They'll put a lien on your property, and when you beat the case, then they'll take it off. Okay. If you don't pay too, they're gonna try to cash in on your car. Okay. They'll probably send you the proceeds. I think they should, but they're gonna cash it in. All right. So also you can do formal cash deposit. As I told you, you got the money. It's a formal reason why you're holding the money from the landlord. Put it inside the courts and let them decide what's going to happen. As I said, now, um, what we say, the first thing you say, what did we say? Very important. Always communicate. Always talk back. Always, not, be in communication. Try to have a good relationship with your landlord. Be funny, because I'm picky. When I go places, even when I look for a job, if I feel something not right, I'm like, nope, we're not about to deal with this. So read your situation, read the world, so you guys just don't move into anywhere. I know we are all in financial situations, but please use your discernment. Know that there's filing fees with some of these actions, so you want to be prepared. Filing fees is not a lot, but you want to be prepared. There is a appeal process that you can go through. We explain that. You want to go to the courts and find out the flow of that appeal process. Hey, so what can I expect with the appeal process? Well, the higher courts will notify you at this time, and then they'll probably request your records. Your records will be sent up there, or those type of things. This is not criminal court, so you don't have to pay for your transcripts. I won't think to go to higher court, but you want to verify that. Okay. If it's criminal court, you got to pay for your transcripts and submit it with your appeal application. But with your appeal application here, when you do appeal, you also want to submit your bonds. Okay, with the appeal process, what type? If you did a bond, if you did a cash, or if you got a fee waiver. Okay. Um, Also, if you lose the appeal, what happened is that the lower court can do two things. They can bring it back down and have you have another trial if they feel like that. And I told you the reason why they would do that, or they'll just throw it out, and then you'll have to pay all the money. But at least you delayed everything for a good 6 months, possibly. This is like a 6 month process. So remember that deadlines is important. Keep to the deadlines, write it down, take a picture, put it on your iPhone, schedule it. Make sure that you put it 2 days before it's due, and then the days before it's due to remind you. Some people just bad like that. Hey, just do what you got to do to succeed. Know the time frame for when you have to appeal. Know the time frame for when you have to answer any questions asked to you. Know that appeals usually are 20 days, no more than 20 days past the court date, usually, but you want to verify. File one time the monthly payment into the courts first. Hopefully your court date don't take that long. It's not months down the line. But if it is, you want to continue to deposit your money into the lower courts and keep all of your receipts, interactions with the landlord. Any issues you have, you do have rights as renters. Okay. So I want to say thank you for being here with Lashley today. This was a formal live. I hope you guys learned a lot, because I know these were some things that some people just didn't know. I like to do in deep depth research and get the most important things that I can share with you guys that is kind of undertone that they don't want you to know, but we're going to know it. Okay. Either way, as a landlord, if you listen to these methods that renters have to protect themselves or to elongate the process, you will know how long possibly that your property will be occupied. Okay. So let's keep that in mind. I hope you have, before I sign off, Monday, we're going to continue to move down this yellow brick road of landlord tenant court, and we're going to go into untenants. I feel like untenants, people who just not tenants, squatters. Okay, so we're going to find some clips, have some clips to go over squatters. I know we showed you one squatter video, but we're going to go into the horrendous stories of squatters on Monday. And then on Friday, we're going to get into how to address squatters, as well as how to address renters who stay in the property too long. Okay. So yes, we're gonna go back to the landlords. I'm gonna teach you we're gonna have to address it. It's gonna take some time. The courts, but we could do it. Okay, guys. Just remember, we here for it. Take your time, have a goal, and crush it. So I'll see y'all on Monday. Have a great, great weekend.
The real estate market often seems like a distant world where only an elite of experts is successful. In a time of so much uncertainty in the air and bad news, realist investing can seem intimidating. But today, I want to tell you that if you make the right decision today, you can enter the real estate market from the back door. Bad credit record? No credit at all? Do you dread the idea of having a home loan? Do you dream of owning investment properties? You are in the right place and right time, because we have created a program which is a tax lien and deed investment online course of only 14 hours. This course is specially designed for people like you who have big dreams. You will learn at your own pace and everything from your home computer. This is your chance. Join our membership for $19.99 a year. What are you waiting for? Visit our website primetimehomebuyerBuyback.org and sign up today for course access.